Welcome back to the show. My name is John Nothlinger. Today, my guest is Kristin Lis. She is a divorce and family law attorney from New Jersey and happens to work at my firm, NetSquire. She has almost 15 years of experience handling all types of divorce and family law matters. You know, listen, before she became a lawyer, she actually had a whole nother career. She was a special education teacher. And I think that's a great training for being a divorce and family law attorney, which we'll talk to Kristin a little bit about today. She's a trained divorce mediator, which is something that's near and dear to my heart, as all of you that listen and watch this podcast know. You can learn more about Kristin at gethappydivorce.com. Just click on the About Us and find Kristin's name. Thank you so much for being here today, Kristin.
Thank you, John, for having me.
Of course. So we live in this really crazy new world post-COVID, where before COVID, you know, every attorney, you got dressed up in your suit, you marched down to the courthouse for everything. You know, you were meeting with clients in your office. There was paper. And we were sort of jolted into the year. Well, then it was 2020, but we were jolted into like a new era. And that new era has continued in some ways, backtracked in other ways. So I just want to talk to you today about, from a client's perspective, like what is it that clients should be expecting when they enter into this divorce process? What are ways that they can, maybe make their experience a little bit better? And sort of what you've been experiencing. So why don't we start with the dreaded court system? So obviously you're in New Jersey. Tell us a little bit about what has changed since COVID. What's the current state of the courts as you see them? And what kind of experience your clients are having when they come into the courts these days?
Right. So the majority of actions are still being held remotely, but there are specific exceptions. And what I tell my clients is, if we can reach a resolution in a matter, the court practically rewards you by allowing you to proceed in a remote fashion. That's something that's more affordable. That's something that's way more convenient, and you don't even really need to put shoes on. So from the onset, I ensure that my clients feel comfortable working in this virtual capacity, because that is going to pay dividends in the event that we end up in a motion hearing on Zoom, or if we have some interim conference with a judge, or maybe even matrimonial settlement panel. And by getting used to this process of Zoom or Teams or any other format that the court would use, the clients end up being more comfortable in that capacity. And we don't deal with, as I think everyone has seen, we don't have anybody showing up as a cat on the screen. I think we've learned through those mistakes, and we now know that we want to be comfortable. We want to be fluent in the way that this virtual world works. And so in that regard, from the onset, I start meetings in the Zoom format. I find it so nice to be able to see people face to face and really get to know them and their issues. And in that regard, you know, the court has been accommodating people. Years ago, they would have to fly up from Florida if they had a hearing, or, you know, another country, and have to fly in and pay for an airline ticket and pay for a hotel. And now the court can accommodate those people so that they can participate virtually. And I just find that that is such an advantage, and it really provides access to justice and to the court system in ways that previously didn't exist. The court also has made the bold move of turning into digital filing, e-filing. And that also has been very helpful. We're not killing trees as much as we used to, but it's a difficult system to navigate. I'll tell you, there was specific training for attorneys, and to ask pro se litigants to navigate that web of intricacies and make their way through JEDS, which is our judicial e-filing system, is very difficult. And that's one of the bonuses of working with an attorney who knows how to do those things, make sure they get filed timely. And that has been a major improvement since the pandemic.
Okay, let's unpack a little bit of that. And just so you guys listening and watching know, pro se litigant is just our lawyer talk, meaning you don't have an attorney. You're in the court system by yourself. So let's talk a little bit about you giving your advice for clients that are actually going to be appearing on camera. I mean, I know you just said you want to make sure they know how to use Zoom so that they don't show up as a cat. But what else have you been telling your clients specifically whenever they're appearing in court in front of a judge, the do's and don'ts basically of being virtual?
Great question. The first and foremost is to never have the children that are subject of the litigation that the court case is involving in earshot, screenshot. They need to be insulated from this, and it just makes you appear poorly to the court, to the judge, when you can hear your child in the background. It's very insensitive as far as that goes. I never have any problem with anybody appearing from the front seat of their vehicle, provided it's parked. We do not want people driving down the highway while they're participating in these hearings.
You don't want them saying, "Judge, hold on, let me honk at this person."
Hold on, Judge, I just got pulled over. No, not a good move. And as far as that's involved, sometimes that is the private place where the kids are not going to interrupt you, where they're not going to be knocking on the door, and that's showing up on the hearing as well. So I would say make sure from the waist up, you're in presentable clothing. Does it have to be a blazer? No. Should it be a tank top that you wear to the beach? Definitely no. Think about something that you would wear if you went on an interview somewhere, or if you were going on a really nice first date. I would stay away from tiaras. I would stay away from the sequins. But if you have a nice button down or a nice neutral shirt, that's great. We don't want, it's not a fashion show, but far too many people have been appearing in their, Mickey Mouse pajamas. We don't want to do that. We want to keep, as the judge would call it, the sanctity of the proceedings, and ensure that we're showing up just like we would if we were physically walking into a courtroom. So I'm always going to be in a blazer. I'm always going to, appear professional, maybe some pearls. I'm not going to be showing up to virtual court like I just rolled out of bed. And I ask that my clients don't either.
Well, yeah, and you want to be respectful to the court too. You're expecting the judge to show you respect. You got to reciprocate a little bit. I think what's interesting about showing up in court when you're on Zoom is people tend to be more laid back when they're sitting at their house or they're in their car, and they tend to forget that it's a formal proceeding. It is, you have to pretend like you're in a courtroom, and people have a tendency to make comments and to grunt and to do all these things that really aren't very appropriate. Do you talk to your clients about that? Perhaps muting themselves whenever they're not talking? Do you have any of those kinds of conversations? Because I think we both have seen a lot of interesting stuff when it comes to people appearing on Zoom in the courthouse.
Right. And what a lot of litigants don't know is that when the judge is participating in Zoom, often he's in the courthouse and you're appearing on a giant big screen TV. So if you don't think that the judge is catching your snarling face or your eye rolls, they 100% are, and they're recorded. So we want to be careful about facial expressions, about hand gestures. We want to make sure that everything's appropriate there. As far as getting ready for that court appearance or getting ready for that video participation, I always tell my clients, we want to stay on mute unless and until the court staff or the judge asks you specifically a question or wants to swear you in. Then you unmute, say what you need to say, and then mute yourself again. There's far too many little background noises or feedback, and we want to make sure that everything's properly preserved on the record. Additionally, I recommend to my clients, to the extent they can, depending on where they're at during that day, to be on a computer and to also have their cell phone available. I offer my clients the opportunity to text me during the proceedings. So in the same way that back in the courthouse when we were in person, I would hand them a yellow legal pad and a pen, and we'd pass some notes back and forth just to, if there were any certain little things that my client wanted to tell me in the last minute or in response to something that was said. I offer them that opportunity to text me during the proceedings. It actually shows up right on my screen. I'm not looking at my device, but my clients are then aware that we're communicating. I'm virtually hearing what they're saying to me, and nobody else is aware of that. I definitely do not recommend anyone ever use the chat feature within the Zoom, because that's available to the person who set up the Zoom. And if we want to say that the other side is something, we don't want the other side or the judge to know that we think that way. We're going to keep that private between ourselves.
I never even thought someone would do that, but I guess there are people that would do that. It's interesting. Don't ever, I'll add this because I loved everything you just said. And some of my follow-up questions you answered just in what you just said. But what I was going to say is, don't ever utter the words that every attorney has nightmares about, which is, Judge, can I just say something? Just don't. Send the text message. I mean, like Kristin said, your attorney should probably be giving you a way to contact them while you're on these proceedings. Text messaging is a great way, but don't just keep your mouth shut. Don't ever say anything to a judge, because all you're going to do is potentially hurt yourself. And, you might reinforce something a judge already thinks about you. That's that people forget. Judges draw these conclusions about, the people in front of them based on what they've read or what they've observed. And if you just open your mouth and you just feed into whatever they already think, you're just going to make it worse for you. Kristin's a great attorney. Let Kristin talk for you. Don't open your mouth. Don't be your own attorney. I know people they're like, I just have to say something because the judge isn't hearing me. These are minds.
A lot of times the very thing that you think is going to be most helpful or most persuasive is not at all helpful and not at all persuasive. And if you wrote a note in the courthouse or text me now virtually, and I think it's persuasive, and I think based on my experience that this could be helpful, you're going to hear me say, Your Honor, may I speak? And I'll talk as to that. And sometimes the judges will say, I'd like to hear this from your client. Let's put her under oath and proceed from there. But those one last thing, oh, Judge, may I say something? They're not buying it. A lot of times the judges have read the papers before we even arrive. They already have an idea in their head about what they want to do. And only after listening to us do they feel like, okay, my first initial impression was spot on here, or, oh, here are details that I didn't know that will impact my ruling today.
Yeah, I think that's something that most people do not understand, is that most of the time, whenever there's written submissions in advance for whatever it is you're going to court for, judges typically already know what they're going to do before you even show up, or they have a pretty good idea what they're going to do. And I think a lot of people that hire attorneys to go into court think that everything's on the table and their attorneys should talk about everything under the sun. They don't really understand that really our job in a courthouse is really more nuanced than that. It's really about hitting the high points, really emphasizing the things we want to emphasize. I don't think clients really understand that, judges pretty much know what they want to do. I would say most of the time they know what they want to do, if you ask me. I mean, what's been your experience with that in terms of how your clients perceive what happens during a proceeding?
I always like to sit down with my clients before we go to court, also in the virtual format. So we're checking last minute, does the lighting work, and all those types of things. But during that time, I'll talk to them about, based upon my experience, I could reasonably anticipate that this is what we're going to hear from the judge. Additionally, at that time, I say, what my experience has been with that judge. Does that judge read the papers in advance, or is he winging it? Is this a judge who is going to ask counsel to go into a little sidebar, a little conference with just the judge and the attorneys and speak about what some of the issues are in the case, and then come back in now that he's kind of fully briefed or she's fully briefed up on the case? I give them that idea, especially when I know a judge is one that is prone to refer things to mediation, or as we'll call it, punt it. If the judge follows the letter of the law, so to speak, if there's a custody and parenting time issue, that judge may feel that he or she is required to refer you to mediation first before hearing it on its merits or listening to each party's side and then making the call. So to let a client know that we may go in there and you may not walk out with what you want today. It may, and I say walk out, we may log out with what you want. Some of the things will be granted, some of the things will be denied, and some of the things may be referred to a mediation, which means this process is not necessarily over yet, but it also doesn't mean that you lost.
So for those people that aren't quite sure what you're talking about right now, why would a judge, if you say judge, we need you to make a decision on this issue. I mean, let's just say the amount of child support someone's going to pay. Mm-hmm. How can a judge just say, I'm not going to make a decision, I'm going to send you to a mediation process to figure it out? How does that work?
A lot of times it doesn't make great sense, but if there's an underlying issue of parenting time, then the judge may feel hesitant to make a call about child support, because parenting time is one of the things that influences our child support calculations here in New Jersey. Mm-hmm. So if perhaps there's 50-50 custody and one parent moves to a different state, now we're talking about a different number of overnights, and that's going to impact the child support situation. So if the judge has referred people to mediation to maybe work out a new schedule so that the kids can go see mom in Florida on their school breaks or on their weekends, and ensure that that summertime happens, then in the mediation, if they've reached that agreement, they're going to count up the overnights. And then, and only then, were we able to get an accurate child support number. Sometimes the judge may say, you haven't shown up today with any of your income proofs. I certainly can't run child support if I don't have W-2s or 1099s or pay stubs. So when you go to mediation, figure out your parenting time stuff. And if that's not successful, you're going to come back to me anyway. I'll run the guidelines, and you have to bring those things back. So a lot of times it's a matter of efficiency. And a lot of times the court also knows that when people reach agreements between themselves with the assistance of a mediator, chances are that everyone moves forward feeling a little bit better about it, but also being more inclined to abide by agreement that they reached by consent, as opposed to something that the judge imposed upon them. And that's a really powerful thing, because once you leave that up to the judge, the judge may not do what one parent wanted or the other parent. The judge may just do something wildly in between that neither of you were happy with.
And that happens quite frequently. Well, I got to ask you, Kristin, based on the fact that a judge might just send you to mediation anyway, I'm wondering, I just don't understand. Why would you not try to go to mediation in the first place before you go to the court?
You know, I wish more people thought the way you and I did, John, because it would save people so much time and money. And I say, no, let's reach out before we file a motion. What's a letter going to cost you? Ask. And unfortunately, time after time, I get nasty grams back that say, we're going to bring it to the judge. That's fine, because when we get there anyway, he's going to send you to mediation, and we just wasted 2 months. I agree with you, John. I don't understand why that's not our initial go-to. There's very few exceptions where I don't think mediation's going to get it done on the forefront. And those are some rare situations where maybe there's a power control issue, or maybe a very severe history of domestic violence between the parties. Where there's an imbalance of power like that, mediation may not be the best way to do it. However, in New Jersey, we now have mediators who are certified and approved by the court to work with litigants who had a prior history of domestic violence. We're always improving and increasing the programs offered to litigants here in New Jersey. So on the onset, if someone comes to me and I see in their judgment of divorce or their marital settlement agreement that the party should return to mediation if there is any dispute as to the terms here, my first advice is we have to go to mediation first. Because if I bring this to the judge, he's going to say, why didn't you follow this part? So if we end up in front of the judge, I'll say, we tried to go to mediation. Here, we sent a letter. We requested it. We really want to go, judge. Compel them to go.
Yeah, and your client just had to pay a lot of money for the benefit of that even happening, which really kind of sucks. Well, I mean, I think, talking about mediation, one of the other good things that's happened since COVID, as mediation's happening almost entirely virtually now. I mean, there's still certain people that want to go in person, but I would say more often than not, mediation's happening virtually. So since we've been talking about mediation a lot, why don't you tell me a little bit about what your experience has been, both as a mediator and as an attorney representing people going through virtual mediation? Do you feel like it's been effective? Have you had issues with it? Just give us a little perspective on this new world we're living in.
Right. I think that the virtual mediation has been absolutely groundbreaking and transformational for so many people. You can do it from your own private place. You don't have to physically sit across the table from someone you may despise. And as a result, you're in a calmer place. You feel like you're more protected. If you're in mediation with me, we can either sit next to each other physically in the same space, but most times people opt to do that from the privacy of their home. And similar to the way I do work with my litigants and my clients in the court process by having that text feature going so we can privately communicate, we do the exact same thing during mediation. And if we really need to talk with just the mediator, that mediator will, or if I'm serving as a mediator, will bring us into a private chat room on Zoom or on Teams so that we can talk one-on-one with the mediator, or we can talk privately out of the presence of the mediator. And that's really efficient. They used to have to say, all right, well, now you have to walk down the hall. What conference room is available? This, that, and the other. And maybe the other party brought their whole support group and they're sitting in the waiting room. That can be awkward. So we avoid those types of situations. For many people, they really want to limit the amount of times and the amount of contact that they have with their ex, to the extent feasible when you're co-parenting with them. But still, any extra time spent in their presence is usually not a good feeling.
Yeah, that's definitely true. So, when you're going through the mediation process, and again, we've talked about this on prior podcasts, like what mediation is and isn't. So we're not going to dive deep today. But I guess what I'm really wondering, Kristin, is in this new world that we're living in, where you have, virtual mediation, do you still feel like you feel compelled to go to the same, mediators that you've always gone to, or do you feel like you've now got a bigger world of people to look to? And the reason I ask this is because mediators are kind of like, they're almost like therapists. Like, not every mediator is good for every case. So maybe you can address that first question. The second question is sort of like, how do you figure out the best mediator for a particular case? Or do you have a process you go through when you're trying to figure that out?
So as far as geographical limitations, that's fantastic. We can now cast a much wider net, and perhaps the best fit for a mediator is not in our geographical backyard. So before, I would take into consideration, how far of a drive is this for my client? How much will this impact their day? And I would be really hesitant to select a mediator that would be any longer than an hour from the parties, because we're talking about 2 hours of their day being impacted by just travel. That puts a really tough strain on folks who have young children. They want to get the child on the bus. They want to pick up the child at the end of the school day. That goes out the window if we're leaving for mediation at 7 a.m. and we're not getting back until 6. So I always try to consider the other obligations of my clients in selecting someone for convenience sake, but not at the expense of quality. But additionally, now we don't have to worry about the drive time. I can select a mediator from North Jersey, one that's closer to New York City, as opposed to down my way here in Atlantic City, without any type of worry that my client's going to have to drive 2 hours or spend 4 hours of their day in the car, plus tolls. And we can avoid that situation. Now, as far as selection of a mediator, currently, I really tend to go the route of mediators who will offer both in-person and virtual. That way, if we start virtual and we're not finding it's a good fit for the parties, or the mediator doesn't feel like they're being as effective as they could be, we can then switch over to in-person. But for mediators who only offer the in-person option, I have to generally put them on like the shorter end of the list unless from the get-go my client is adamant that it has to be in person. But because from the get-go, when I'm working with my client, we're in this virtual fashion, they learn very quickly that communication through this method can be extremely efficient, can be extremely effective, and they see the value in that. So that's not really hard to sell on mediation. But as we have, a whole new generation of mediators coming up, I think that we will see that there's an increase in attorneys and mediators who are offering that option. So I think that probably addresses those two issues.
Yeah, it does. I mean, I think what's interesting is there is a generational gap anyway when it comes to in-person versus virtual mediation. I've noticed that most people love virtual mediation. They actually love virtual everything. They can sit in their house in their pajama pants. They can relax. They can go to their own bathroom. They can get a drink out of their own fridge. They can be in a more relaxed environment, and I do feel like that promotes somebody being in a better mindset to make a deal. I'm always curious why someone would really demand in-person mediation. It just, to me, and we do a lot of virtual mediation in our firm. That's all we do, and I've never experienced that it impedes anyone's ability to reach an agreement, with the limited exception of people that are just so uncomfortable with technology for whatever reason. I'm not going to make an age comment, but it tends to be older people that just have a little bit more, they just they don't feel as comfortable with it. But other than that, why would somebody want to do in-person mediation versus virtual in your experience?
In my experience, the person who's insisting upon the in-person is either technically incompetent and is just completely terrified by the notion of Zoom, even 4 years into this, or they feel that they can exert more power or control over the other person being in the same physical space. And that's the psychological warfare that I don't think is as prevalent in a virtual format. That person who's insisting upon sitting across from their ex probably has a history that's leading us to this point where they still believe post-divorce or during the divorce that just being in their physical presence will intimidate them, will disarm them, will take them off guard. And it can be some emotional and mental control, pressure, coercion, without anyone outright making a threat, but just based upon past experience, being physically in that person's presence can really have their nerves shot.
No, I think that's right. I want everyone listening, the non-attorneys listening, to really consider too that the whole process can be much quicker if you're virtual. And I'll give you some examples. Usually if you go to someone for in-person mediation, they're going to put you in two separate rooms, almost always. I mean, some mediators do everything together, but more often than not, if there's two attorneys, they put you in two separate rooms. So now you have a mediator having to walk back and forth between these two rooms, gathering up all their documents, all their notes, and moving to the other room and then reorganizing them. If it's virtual, someone with a click of a button can go from one room to another, talking to everyone in mediation. They have all their notes right there. They have their notes on their computer. They're so much more efficient. And not only that, you said this earlier, but you don't have to pay your attorney to drive somewhere and then to wait at the office for the other side to show up. Because, these days, I don't feel like anyone's ever on time for anything anymore. And so you're saving all that time and money, but you're also saving the time and money of the mediator. I know you're very technologically savvy. I know I am. But on mediation, a mediator can share their screen and start typing something up. Everyone can see what's being typed at the same time. You can sit there and collaborate. When you're in an office, what do? The mediator goes back to their office, types it up. Then they print it out. Then they give it to the parties. And then they have to look at it and handwrite change. The whole process takes longer and is much less efficient. And I think the one thing that if anyone takes anything away from our conversation today, it's really that I want you to understand that the virtual world of divorce now that we're moving towards progressively more and more is a good thing. It's not a bad thing. It's a very good thing. And might be funny coming from two attorneys, because I know we all get a bad rap, but we think it's a good thing that our clients are spending less money. They're spending less money on things that don't advance their case. I mean, like, does it really advance your case to have Kristin drive from Atlantic City to Camden? No. All it did was, she's driving. I don't know what you do in the car, Kristin. I mean, listen to some music, do whatever. But guess what? Unfortunately, you have to pay your attorney to do that, because they're the one using their time to go to court. Instead, she used that hour at her house to really prepare for your case, and be ready right when it starts, as opposed to preparing the night before or whatever. Because, unless I guess you're in one of those self-driving cars, you can't sit there and prepare in the car, right? But I mean, I just think that what's really concerning me right now is how many people in our world, in our divorce world, are so wanting to take a step back and to go back to this paper world where everything's in person. Do you have any sense on why that's happening? And what would you tell someone who's out there looking for a divorce attorney, who, you've got divorce attorney A that's like, you're going to come in person with all your papers, all this stuff, and divorce attorney B who's, no, I want you to upload everything to a portal and then we're going to Zoom. Like, what would you tell someone who's like generally doesn't know, like, I don't know what I'm supposed to do. I don't know who I'm supposed to hire, because it sounds like the one in person, that's kind of what I know of being an attorney. I think that sounds like a better deal for me. What would you tell somebody?
So interesting enough, I serve as a panelist in a couple counties for our matrimonial settlement panel. And this week I had the opportunity to panel one where a new attorney had just come into a case, and she was desperately trying to get a copy of the file from the old attorney. These attorneys thrive on the old way. We've got, the wooden paneling, we've got the library of books on the wall, but they're still using paper. They still have the giant banker's box. And so the process of copying all that and providing it to, it's taking months. Meanwhile, if I'm in a digital world, I gather one folder, click, copy, paste, send, and everything's there. When we talk about sharing documents with clients, it used to be that we would receive a copy. And I say we used to. I've always tried to incorporate technology into my practice since I started 2009, 2010. And what they would do is they'd get a letter, they'd make a copy of the letter, they'd type a cover letter to their client and say, "Dear so-and-so, here's the letter from so-and-so. Let's set up a call, or why don't you come into my office with a meeting and discuss?" And then that would be a 7-day turnaround time right there. As things are right now, I get a letter from an adversary. I share that with my client. I typically get that client's feedback within 24 hours, and I'm responding back to the adversary. What used to take weeks is really just taking hours or days now. And that also impacts settlement. It used to be that people would dictate to their secretary, or that they would have a typewriter. I keep my marital settlement agreements up on the screen when I'm talking with clients and make those changes in real time, so that by the end of our meeting, they already have a revised draft sitting in their mailbox. So it definitely does streamline. And your question as to why are people so hesitant, I think a great answer to that, twofold. One, they've done it the same way for so long. No one's going to tell them to do it any other way than they were taught in 1991. And we're going to continue doing it that way. And yes, I still have a fax machine, and I want
everyone had a fax machine. I'm like shocked that anyone has one.
I say I don't have a fax machine where I'm at. Where I'm at is 2024.
Oh my gosh.
That's where I live, 2024. It's like a carousel of progress in Disneyland. We are in that last one, the one that was the future. We're there. So no more faxes. As far as the second category of folks who are insisting upon the paper, insisting upon the in-person meetings only, I have a tendency to find that they feel like you're only legitimized as an attorney if you have your name on a sign outside of a building and your name on a door. And if you have a beautiful law library in your office, everyone will be so impressed by it. And so it's all about image and perception. And I have never had anyone feel like I am a lesser than, or that I'm incapable of handling their matter simply because I'm working from my home, or I'm working from a conference room at the courthouse and they're at home where they're comfortable. So I think that there's two key types of people who insist upon doing it the old way, and it's in ways that serve them best, not ways that serve their clients best.
What I think is interesting about those two kinds of people, on the second one, the one where image is so important, I just want to remind everyone who's looking for an attorney, you pay for that. You pay for that because it costs them more, and you pay for that in ways that we could have a whole podcast about, but you pay for that. But on the first one, where it's people that are sort of like, this is the way I've always done it, I'm not going to change. I want you to be very cautious, because that's not just on handling how they're doing your case, like in terms of the process of paper and stuff. That's also how they're going to do the substance of your case. And what I mean by that is, those are people that are more likely that every single divorce that walks into their office, they handle the exact same way. And I don't think there could be a bigger disservice to any client, I don't think you're going to disagree with this, Kristin, than to handle every divorce the same. Everyone is unique. I mean, yes, everyone got married and now they're getting divorced. Okay, that's where the similarities end. But like, what does someone need? What is the best process for them to get divorced? Do they have kids? What is it that where they are emotionally? Like, everyone's very different. And I will tell you, and I've said this so many times, I'm just going to keep saying it. If you walk into an attorney's office and they tell you, the first thing we're going to do is file a complaint, and they cannot explain to you why there needs to be a complaint right then and there, you need to turn around and walk back out and go interview other attorneys. Unless an attorney can explain to you why they're doing what they're doing in your specific case, they are not the attorney for you. I've said that more times than I can count, but what is your perspective on that, Kristin?
You do not want cookie cutter. If you wanted cookie cutter, you would just ask your friend what their marital settlement agreement looked like. But your friend is not you, and the guy down the street is not you. You need an attorney who can look at your perspective and your life and start working with you on real solutions that work for your family. I frequently work with families where we have law enforcement, fire, or maybe even nurses who have 12-hour shifts. We need to get really creative, but really practical when it comes to parenting time. And so many attorneys that I've been against in cases as an adversary, they run the typical, because of their work schedule, I guess we'll see them every other weekend. No. Let's look at what really, really will work here. We can get creative here. The typical mindset that you're talking about was that they're so attached to the idea of paper. They're so attached to the idea of being in that same office space every single day. Those are the same people who are going to say, this is the way I've done every case from the inception till now, and maybe not even really think about the way that the law has evolved over time to meet the current realities of families and to think outside the box. Do we really need to follow the court holiday schedule? Does anyone in your family even care about Easter? Why are we fighting over this holiday that no one cares about? What's the family dynamic, and what do you see your life looking like after divorce? So talking to each individual person is so important in getting to know what their needs and wants and desires are, but also putting a very practical spin on it and dissuading any, sort of notions that, the way that it happened for your friend is exactly the way it's going to happen for you.
Yeah. I really feel like, when you go into an attorney's office, you really should be able to walk out and look at yourself in the mirror and say, this attorney just created a plan for me, for my family. And an attorney needs to listen to you too. I mean, this is one of the things that I hear more complaints about than anything else, is that people don't understand why their attorneys are doing what they're doing. They're just seeing bills, but they haven't been told like the why. Like, why are we doing this?
Yeah.
They're not being told what is going to happen. You just used the word early settlement panel, which, if you're listening to this, you don't know what that is. It's just something that happens in New Jersey, usually about like 6 months into a case, where other attorneys will help try to resolve your case with your attorneys. But, I've talked to people that weren't even told that even happens until like a month before it's going to happen. Mm-hmm. So, just be really careful when you're hiring an attorney. You want somebody who's going to create a strategy for you and your family. You need someone who's going to explain to you what's going to happen. Unless you're getting divorced for the second or third time, you don't know what the divorce process looks like. I mean, you really don't. And you really want an attorney that's going to put that together in a very cogent way and talk to you like a layperson. That's the other thing, by the way. I mean, I could talk about this all day too. Attorneys are obsessed with sausage making. They're obsessed with it. And clients don't care. They don't care. They just want to know, this is what I'm looking for. They don't care how it's going to happen. They just want to know that they're going to be okay. They're going to have enough money to support themselves. Their kids are going to be okay. They're going to go to the right school. And so I really feel like, this whole, the old way and the new way. We started this conversation about technology and the way things have changed, but really it goes right into substance and how a divorce is done, how it's not done. I want to sort of, going into that a little bit more. What do you do, Kristin, when you've got a client that comes to you and you've gone through the whole thing, you've come up with this creative solution, you've come up with this like step-by-step, here's what we're going to do, your client, and you are comfortable, like your client's like, oh my gosh, thank God I found you because you actually heard me, you listened to me. And then their spouse goes and hires Dinosaur, who's, the little arms. Like, what do you do then?
We have another conversation. and here again, the benefit of doing it virtual. I receive papers from someone who I know is not amicable, who is not initially focused on, can we get this resolved? They initially have it in their head that this case will go to trial. Well, realistically, 98% of cases settle. So I don't know why they're worried about the 2%. I want to keep it as amicably focused as possible for folks. And when I see that, I pick up the phone. I go, all right, well, guess what they did? That's going to throw a little kink into the mirror. And we can expect to be on the receiving end of things that aren't necessarily being requested by your spouse. This is just the same cookie cutter way that this attorney does this in every single case. And they don't feel like they're doing their job until they do all the things that maybe not are even necessary. So one thing I was thinking about recently is how I will have strategy sessions, not only at the beginning of the matter, but throughout the matter to continue to stay in touch. I work with my clients to decide, how do we even want to get the person served with the complaint for divorce? To give them some power and some choices in the matter, and maybe choose a less dramatic fashion of having someone served. Meaning maybe an officer doesn't go to their place of employment and say, you've been served. What's a more private way that we could handle this to have respect from the very beginning? Another option that I talk with my clients about is what's called discovery. And John, this goes back to, you said I was a teacher before. That's how this works into being a divorce lawyer. I want my clients to understand what it is and not just say, well, we have discovery. I say discovery is a fancy name for sharing stuff and information. And I say it's broken down to two different things. We've got interrogatories, fancy word for questions, and notice to produce or request for production of documents, document scavenger hunt, dig up all the stuff. And We talk about, do we want to ask 2,000 questions? Do we want to answer 2,000 questions? What is it we really need to know in order to feel comfortable reaching a settlement here? Or do we already have a settlement and we can avoid discovery entirely?
Yeah,
So,
like is it all joint accounts that you can go and get yourself versus spending all this time and money? I'm totally with you. I mean that like this, but I think the bottom line or the takeaway is that your divorce should be unique for you,
mhm,
and your attorney should be able to explain why this needs to happen in your case. And if
mhm,
it's just, well, this is what we do in every case,
right.
no. No, 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 no. A lot of times attorneys are doing it this way because they think that's the only way to protect themselves, and protect themselves from you being upset later on. You know what? I look at every single client as an adult. If you tell your client everything, let them make the decision. Like
Mhm,
if you say, listen, we could ask all these questions, but if you feel reasonably comfortable because you were married for 30 years and you and your spouse were really good for 27 of that and you know everything that's going on, if you don't feel like we really need to ask all these questions, then we won't. But you make the decision. I'm not going to make the decision. You make the decision what we need to ask. And I think at the end of the day, if your attorney isn't informing you about what's going on, isn't explaining why they're doing what they're doing, and doesn't let you make the decisions and control your own case, because it is your life. It's not
mhm,
my life. I mean, after we divorce people, I mean, I stay in touch with people. I know you do too, but
mhm.
like, move on with your life. It's like we're not part of your
I
life
love seeing them
anymore.
live their best lives. That's the best.
Yeah, it's like, but it's driving me crazy how how I thought after COVID and we had to be pushed more into an electronic world and a world where now AI is being used. I mean, that's a whole nother thing that's starting to come up. Um,
Mhm,
there are attorneys that are just staying in the past. And I do think that the time's going to come, and it may already be here, but the time's going to come where clients that go and hire those attorneys are going to be at a significant disadvantage in all kinds of different ways.
mhm,
And so when you're looking at attorneys, first of all, I really encourage anyone listening to interview more than one attorney. Don't say because your best friend went to John Smith and John Smith got her, all this alimony and got her custody of her kids and whatever other nonsense. Don't just go hire him. Like actually look around. It's very similar. It's not exactly the same, but it's very similar to like whenever you get a therapist. Sometimes you'll go meet with a therapist and you're not a connection. There's no connection. You don't feel comfortable. You got to go meet with various people. There's nothing wrong with interviewing a couple of attorneys to make sure you got the right person. And I would say that even if you get a great referral, you
mhm,
get a great referral, what was good for somebody else may not be great for you. And what you don't want to happen is you don't want to get somebody who's like, okay, you have to go hire this person. You go hire them, and now you've been with them for 6 months, and you realize this is not a good fit for me. And now you're going to hire somebody else, and you have to tell your story again and get somebody else to do it all again. Take
mhm.
some time, actually look and make sure that the attorney and you align on what you want and how you're going to get there. And that's what we've been talking about throughout this whole podcast today is just really understanding the reality of the world we live in now, the way the courts work, the way attorneys work, and that you need to really find somebody that's going to make you comfortable. So if for you, technology is something that scares you, looking at a computer gives you the willies and you don't even know how to upload anything to the internet, you might need somebody that is comfortable with paper and is at an office where you can go and meet with them. But if you're comfortable with technology, I can assure you your case will proceed faster, it will be cheaper, you'll be more efficient, and you'll be able to do things that other people can't do. Like you pointed out before, Kristen, like you need to pick up your kids from the bus stop. Well, you can still have your meeting with your attorney over Zoom at 2 because you can just say, okay, can we just pause this for like 5 minutes so I can run out and get my kids? You
Mhm.
can still do all those things that you can't do whenever you're relying upon, I'll call it the old way. So I,
Think
I
about
really,
how powerful lunch hour is. In the past, you had an hour for lunch, if you're lucky. You'd what, spend 25 to 30 minutes getting to your attorney's office to turn around and spend 25. There's no way you have an appointment on your lunch hour. Now, from the minute you clock out at work, that can be a very productive meeting with your attorney to maybe review some financial documents or talk case strategy. And so, it really does fit into your life without making you, miss your yoga class or miss your early morning workout or those types of things, so that you can still maintain that balance for yourself during a stressful time that could be the divorce.
Oh, early morning workout. I need to get back to doing that. Oh, I just was thinking about that today. You know what? And it actually goes well with this topic of divorce. People, when they become stressed out, whether it's, work or they go through a divorce process, they tend to forget about all of those things to do self-help. They're, exercising, eating well, therapy, whatever it is. And, like Kristin just said, you'll have more time for all those things to really keep your mind and your body in a good place so that not only can you think about divorce clearly and without emotion, which it's emotional, okay? It's emotional. But if you really want to get through divorce quickly, you need to be in that place, that mindset of this part of my life is ending. It ended for whatever reason it did. Even if you were hurt, it ended. I need to move on to the next chapter of my life. And this process I'm going through is literally just like someone taking a page and turning it.
Yeah.
And it doesn't have to be difficult. It doesn't have to be, the page doesn't have to be made out of like titanium where you need like 1,200 people to help turn the page. It could just be made of paper. And I think people just get really, they lose sight of all of this. And I do think what you just said, that's why what you just said reminded me of all of this, because you're right. If you do things virtually, if you do things electronically, you have more time for yourself. And I can tell you, people do not spend enough time on themselves during a divorce. And that is the number one reason divorce gets so crazy, is that people are, you probably have a million cases where 12 months in, you're still hearing about why they're getting divorced. Yeah. And you don't want to tell people it's not important, but unfortunately we live in New Jersey and in the United States where everywhere now basically is no fault. So it doesn't matter why you're getting divorced. It matters to you. It like it's part of your body, but it doesn't matter. And, so if you kind of just look at everything we've talked about today, the theme is the same, which is that divorce in 2024 is not divorce 10 years ago or divorce 20 years ago. You cannot think about, you can't look at a friend that got divorced 15 years ago and expect your divorce to turn out the same. But you also need to make sure that you surround yourself with people that can help you get through what it looks like today. And that starts with an attorney who is, first of all, comfortable with the way the courts are working out. As Kristin just pointed out, a lot of courts are doing things virtually. It's kind of a pendulum right now. I feel like it swung a little bit back toward a little bit more in person, but I anticipate it's not going to be long before we kind of swing back where there's a lot more virtual again. You want a attorney that's comfortable with that. You want a attorney that's comfortable with the electronic way things are working. Kristin was just talking about how more and more the courts are getting all electronic. So obviously you need an attorney that's savvy and understands how to do all of that. And then third, you really need an attorney that can help facilitate your understanding of the process and really can make you feel comfortable that you understand what you're doing, why you're doing it, and that attorney really understands you and your family. And I think we covered a lot of things today. We could go in depth on just about all of them. But I think that if you're considering divorce and you're looking for who can help you, I hope that our conversation today at least gave you some guideposts to help you through the process. But on that note, Kristin, so why don't you tell our listeners where in New Jersey you practice, and if anyone is interested in speaking to you a little bit more, how they would contact you.
Great. Thanks, John. Since I clerked in 2009 in Atlantic County, I have been deeply involved in the Atlantic County area, Cape May, those are all one vicinage. I focus my practice on what I call the 7 Southern counties of New Jersey. So that would be Camden, Burlington, Gloucester, Cumberland, Salem, Cape May, and Atlantic. But the wonderful part of working with the team at NetSquire is that our team can handle cases throughout the state on a wide variety of family matters. So while I may not handle something specifically in a more northern county, or I may not work on domestic violence cases, the firm itself does. So it's really nice that maybe an associate of mine will handle the domestic violence matter, but I'll focus on the divorce or the custody matter. And so we can also kind of play good cop, bad cop in that regard. I can be the reasonable one that's working out the deals. And meanwhile, my associate can go get you that restraining order if the situation has arisen to that. So wonderful part of working with the team here, and that we all stay in touch, and that technology is such an added bonus. We're in almost constant contact with each other, either through email or Zooms, speaking with each other. We assist each other with brainstorming in cases that may be unique, or maybe there's a case that involves a special education child, and I can offer some advice and input there. So people would get in touch with me by going to our website, and that is netsquire.com, or gethappydivorce.com. And you can check my bio there. You can book a discovery call with our happiness coordinator. And you also can, if you're interested, book a one-on-one consultation with me to just kind of see if we're a good fit. Like John said, I always think about the initial consult as like a first date. We're going to be on our best behavior, but I want to know if I connect with you, and you want to know if you connect with me. Maybe after speaking with you, I think you're an awesome fit for working with John, or maybe you're an awesome fit for working with another associate in the firm that I think the two of you would connect better. That doesn't mean that I love meeting with people and hearing about their issues, because I immediately go into problem solving mode. So having that opportunity to speak with folks about their issues, and sometimes, John, when I have a consult, maybe their case isn't ready yet. Maybe they want to go try couples counseling, or maybe they are required to go to mediation and that former marital settlement agreement. So they may consult with me, and the answer may not be hire me right now. It may be come back after mediation, or it may be you try that couples counseling, and I'm here whenever you need me. So again, each individual case, no cookie cutter here.
Awesome. Yeah. And I can tell you one thing, Kristin's going to tell you what you need to know, not what you want to hear, which is very important when you're going to see an attorney. If you have an attorney who's like, oh yeah, you're going to get everything, don't worry about it. Yeah. Again, turn around and walk out, because it's never going to happen. Well, thank you so much, Kristin. I know everyone listening and watching got a lot of great information today. And again, if you live in we'll call it the southern part of New Jersey, Kristin is very familiar with all the counties. She knows all the judges. She's like very, very into all of those counties down there. The counties where I'm like, wait, where's Cumberland County? I don't know where that is. I know it's south, but I mean, do I have to drive to Philadelphia first? Where do I go? I don't even understand. She does all of that. But listen, if you want to learn more about Kristin, her link will be down below this video or in the podcast description. And you can call her, you can email her. And if you have any questions, I'm sure she'd be more than happy to answer them. Thanks so much, Kristin.
Thanks, Sean.